Welcome to the Employment Law and HR Podcast with your host, Alison Colley.
Hello and welcome to this episode 206 of the Employment Law and HR Podcast. I'm your host, Alison Colley. I'm an employment solicitor and HR specialist, and I run the firm Real Employment Law Advice, where together with my colleagues we provide advice and assistance to both employers and employees on all aspects of employment law. So, if you have any questions about employment law, whether as an employer or an employee or a HR professional, then please don't hesitate to get in touch with myself or one of the team. If you call our head office, the number is 01983 897 003, and speak to the lovely Kathy, who is our administrative assistant, she will be happy to arrange a time for an appointment with a solicitor for a callback, or if someone's available, she'll put you straight through. So please don't hesitate to get in touch. Don't spend ages Googling things. Give us a call and we'll be happy to chat through with you. Now, in this episode of the podcast, I'm going to be covering off two topics that I think you'll find interesting. So without further ado, I'm going to get into this week's featured content. Now, the first thing that I want to cover is something that's a little bit exciting for us employment lawyers. And you might be thinking, yes, Alison, you're very sad. But for the first time in a long time, there are significant changes that look likely to take place in relation to the employment law and employment law rights. And that is that last week, the government announced that they were going to be making changes in relation to certain laws that were derived from Europe. So you may recall that they introduced the Sunset Bill, I think it was early this year or late last year, which basically said that, in essence, they would be scrapping all EU-derived laws at the end of 2023 if they haven't been retained specifically. What they've now done is they've sort of reversed that. So they're saying that they will retain EU law unless it's been specifically revoked at the end of 2023. Which makes sense considering how much of our laws come from the EU and what a huge task that would be, how confusing it would be for everyone. And as their main driver seems to be to reduce sort of admin for employers and businesses and take away any obstacles for businesses for growth, then it seems more sensible to do it this way. But as a result, there are a few things which, to be honest, we're kind of on the radar of most employment lawyers anyway, that the government have announced they're going to look at and change in relation to those EU rights or EU-defined rights. So the main things to note at this stage are, one is in relation to the working time regulations. So they are currently saying that there's a huge reporting burden for employers, that the working time regulations from EU legislation, whilst providing valuable protections, they are overly onerous and administrative for employers. So they're looking at making some changes. So what does this actually mean? Well, it means that they will remove the requirement for working hours to be recorded, and that is for most workers and employees. I'm not really sure how this will work in relation to national minimum wage requirements because, of course, you need to retain records of how many hours people work to ensure that they're being paid correctly under national minimum wage, but I'm sure those kind of details will be ironed out in future. The next thing is simplifying the calculation of holiday pay. And for those of you who have listened to past episodes in relation to the recent case of the Harper Trust in relation to holiday, you will know how confusing this is. And as a team here at Real Employment Law Advice, we literally go cross-eyed as soon as anyone asks us to look at holiday pay or entitlement. So this would be a welcome reform for us as a team, but I'm sure it will be for you too. So basically simplifying that calculation of pay. The next thing is, I think fairly sensible, is the introduction of rolled up holiday pay. So you may know that the payment of holiday other than at a time when someone leaves their employment, so payment in lieu of holiday, is unlawful. Although many employers still do it, I have to say, particularly in 0-hour contract situations where it's much easier just to pay a payment towards holiday entitlement every month, but it is currently unlawful. So it does create this issue for employers and employees where there's some uncertainty about whether if someone becomes aggrieved, they're going to raise a complaint or not. But in essence, what they're proposing would, I think, be a welcome change, which is to enable employers to pay rolled up holiday pay. As I say, it's particularly important, I think, for casual and seasonal workers who aren't that bothered about taking holiday time and being paid for it, but would rather have that additional pay each month. And then finally, they're looking at merging the two separate leave entitlements. So currently we have the 4 weeks leave, which is derived from EU law, and the additional 1.6 weeks, which is derived from UK law. And that has led to some kind of anomalies in relation to the application of those and how that works in practice in terms of the calculation of holiday pay, etc. So as you may know, again from previous podcasts, that under EU law, the 4 weeks, you're required to calculate holiday pay using things like commission and that sort of thing, but there's not necessarily the requirement to do that for the additional 1.6 weeks. So by bringing the total entitlement 5.6 under the same legislation, then the same rules will apply to that. So some welcome changes, I think, in relation to working time regulations and in particular the burden on employers, but also creating some certainty for employees. The next point is in relation to the fantastic TUPE, which is the Transfer of Undertaking Regulations, which in summary is law that applies where employment is transferring from one employer to another. The most obvious situation is where there's been a buyout of a business or where there has been a service provision change. So let's just take quite an obvious one is a cleaning contract. So company A contracts with the cleaning company to provide their cleaning services. Company A then gives notice to the cleaning company and takes on company B to provide their cleaning services. So the employees, although they're employees of company A, because they've been providing their services on that contract to that company, will then transfer to the new service provider. So that's really short explanation about TUPE. Now, with TUPE, which is derived from EU law, comes a number of obligations on businesses in terms of their requirement to inform and consult with employees. And currently, the law says that if you have less than 10 employees in total as a business, then you can consult directly with those employees who are affected by the transfer. Otherwise, if you have more than 10, whether or not they're affected by the transfer, you would have to go through a process of electing employee representatives, or at least giving the opportunity to elect employee representatives, and then you would have to consult with those representatives rather than the individual employees. The proposal is to remove that requirement so that it's for businesses with fewer than 50 people, so 50 staff in total, where the transfer affects less than 10 employees. Initially, when you think about it, you think, oh, businesses with fewer than 50 people, that'll really help. But those transfers that affect more than 10 people will still have the same requirements for election. It's a bit of a change, and it may make life easier for employers in TUPE situations, but it doesn't go far enough, in my view, in relation to that. And the third thing is, I don't know if this has come completely out of the blue, or I'm not really sure where it's come from, because the TUPE changes and the working time changes, you can kind of see where they're coming from. TUPE's been an unwelcome piece of legislation for years, and there have been lots of issues about holiday and working time, so I get that. So I'm not really sure where this third point comes from, or what the motivation is behind it, but in essence, they're saying that they would restrict non-compete post-termination restrictions to 3 months by law. Now, I think the driver behind it is to ensure that there is the ability for employees to move around, to increase competition, to help to grow the economy, maybe. But in essence, what they're saying is if you have a post-termination restriction in your employment contracts with employees, it would be illegal to have anything more than 3 months there. Now, what I would say about this is actually for a number of years, probably for as long as I can remember even, I've been advising employers to steer clear of post-termination restrictions that have non-compete, so that's where they're not allowed to go and work for a competitor for a period of time of longer than 3 months anyway, because it's very, very difficult to justify a post-termination restriction of longer than 3 months. You know, it has to be kind of a really senior person, or it has to be someone who has access to certain information or can really do damage to the business to justify a post-termination restriction for more than 3 months where it's non-compete. Now, this is restricted again, to non-compete clauses. So it does mean that an employee could move to a non-competitive business, and the restrictions there would be different. So what we would often advise you to do in relation to post-termination restrictions where you're concerned is to have a whole suite of restrictions in there. So you'd have non-solicitation of customers or clients, non-dealing with customers and clients for a period of time, non-solicitation or poaching of staff, those kinds of restrictions that would help to protect your business for longer. And you can justify having those for 6 or 12 months. It would also be important to utilise a garden leave clause if you are concerned about someone taking information to a competitor. So yes, I suppose it provides some certainty to employers who may not be getting advice about their contracts to make sure that they limit those restrictions to 3 months. But as I say, you know, most employment lawyers would be advising that actually non-compete clauses of more than 3 months would be difficult to justify in this sort of day and age. So those are the 3 areas of change that are proposed, and everything I've read about these changes is that it could happen fairly quickly, although obviously it's subject to time of the government to be able to put them through. If you are concerned about these or how they may impact your business, or whether you need to make any changes now or not, then don't worry. If you listen to this podcast regularly or you subscribe to our newsletter, then we will keep you up to date on that. So you will know exactly when they come into law and when you need to make any changes and exactly what you need to do on a practical level. If you have any concerns before that, you can always contact myself or one of my colleagues and we'd be happy to chat. You can email me. My email is alison@realemploymentadvice.co.uk, or you can call the head office on 01983 897 003. Now, the second thing I wanted to cover in this podcast is to briefly talk to you about a case that's recently been decided in the Employment Appeal Tribunal, and it is about furlough. Do you remember those days when we used to talk about furlough all the time? It feels like I haven't said the word furlough for several years. So it's an interesting case which I thought I would bring to you, and it's about unfair dismissal and redundancy. So the case is Lovingangels Care Ltd versus Mhindurwa. I hope I've said that right. I probably haven't. I'll put a link in the show notes so you can find the case yourself. But in essence, the Employment Appeal Tribunal here, we're dealing with a decision that had been made by the Employment Tribunal that an employee had been unfairly dismissed when their employer had failed to consider the possibility of furlough as an alternative to redundancy dismissal. So the Employment Tribunal decided at the first instance that it was unfair dismissal and the case was appealed. So this is the outcome from the Employment Appeal Tribunal. Now, as they have done in the case reporting on this, I'm going to refer to the employee in this situation as M, just so I don't keep butchering their name and saying it wrong. So the employee M had worked for Lovingangels Care Ltd as a living carer. And when the person who she cared for went into hospital, the employer didn't have any immediate work available for her, and their live-in work had been significantly reduced due to the COVID-19 pandemic. So ordinarily in this situation, where the employees were assigned to a specific person to care for and they were in hospital or for whatever reason didn't require care, then the employees would normally be transferred to care for someone else. But because of the whole COVID situation, there wasn't that work available. Now, the employee in this situation applied to or requested that she was placed on furlough, as obviously there wasn't the work available for her and the person she cared for was in hospital. But the employer refused, and instead they terminated her employment by reason of redundancy. So they said, the work that you undertake or you normally undertake is not available, we don't have any alternative for you, and therefore your position is redundant. The employee then made a claim in the employment tribunal, and the employment tribunal decided that the employer had failed to properly consider the alternative of furlough at that time. Now, you may recall at the time there were a few conversations that took place about this and a few questions that arose as to whether you should use furlough as an alternative to redundancy. And the idea was, or the advice that we were giving at the time, was that there wasn't any obligation to put someone on furlough, but it was something that you should be considering as part of the options at that time, particularly if the redundancy had arisen as a result of the COVID pandemic, which it had in this situation. So what the employment tribunal said was exactly that. The employer had not considered or given proper consideration to the possibility that the employee could have been placed on furlough. As with all things in relation to employment law, the employment tribunal decided that it would have been reasonable for an employer at that time to have looked at the furlough scheme. The whole point of having the furlough, or the coronavirus job retention scheme as it was known, in place was to avoid the situation of redundancies as a result of the COVID pandemic. And the employer in this case hadn't acted reasonably because they had just discounted it, even though the employee had raised it themselves. The Employment Appeal Tribunal in this case have agreed with the Employment Tribunal. But what I find interesting about their judgment is that they made specific reference to the fact that although we had the COVID-19 pandemic and the special circumstances around that, it didn't alter the legal tests that needed to be applied when deciding a claim for unfair dismissal. So there was no actual special approach for employment tribunals, and they didn't have to make a special consideration in relation to COVID. It was still the same tests of reasonableness and all of those sorts of things. But it was acknowledged that it was an extraordinary circumstance at the time, and that there was an additional layer there, if you like, of alternatives for employers to consider, or for reasonable employers to consider. So ordinarily in a redundancy situation, you look at whether there are alternative vacancies, any ways in which you can retain employment. And in this case, the employer should have considered putting the employee on furlough and then placed it under review potentially if the redundancy situation was continuing. What's interesting about this case is that the Employment Tribunal and Appeal Tribunal said that the employer acted unreasonably, and therefore it was an unfair dismissal, for failure to consider furlough as an alternative to redundancy. What they didn't do was go as so far as to say if the employer had considered furlough but had discounted it as an alternative and then made the employee redundancy, would it still have been unfair? I'm sure that there are other cases in the pipeline in relation to that kind of question, and fortunately we don't have to worry about it now because that situation has passed. But it does raise some interesting issues and just reiterates in relation to what's happening in the current times. As an employer, you need to explore all alternatives to retain employment before reaching that final conclusion of dismissal by reason of redundancy. It's also, as I say before, really important to get advice, and if you have any questions about this case or anything else, then please don't hesitate to get in touch. I will put a link to the case in the show notes so you've got the details if you want to have a look at that. And if, as I say, you want to chat it through or you have any experience in relation to this particular issue and you'd like to come on the podcast and talk about it, I'd really welcome you as a guest. I'd love to hear from you. You can email me, it's alison@realemploymentlawadvice.co.uk. Before I sign off, I just want to remind you about our fantastic flagship service, which is our HR Harbour. Our HR Harbour is an ongoing support service for employers and HR professionals where we provide ongoing employment advice and HR advice for a fixed monthly fee. There are 3 levels. Our silver service starts at just £175 plus VAT per month. So if you'd like to get in touch for a no obligation discussion about this and how we can help you, I would love to hear from you. I hope that you have a fantastic week ahead, and I look forward to bringing you the podcast in 2 weeks' time. Thanks for listening.